Okay. Good afternoon, class. Good afternoon.
Good afternoon, Prof.
Good afternoon, sir.
Okay.
Good afternoon, sir.
It's our Thursday. I see there's one demon who used to hold our Thursday lecture. Okay. Yeah. Yesterday, while we are waiting for others to join, I think we have the capacity of 300, I guess. As people are joining, let's just do a recap of what we did last Tuesday. Now we look at alienation of right of occupancy. We examine section 21 and 22 of the Land Use Act. And we said that shall be unlawful for an holder of a statutory right of occupancy granted by governor to alienate his right of occupancy either by way of an assignment, mortgage, transfer, grant without the consent of governor first had and obtained. And we said that failure to obtain governor consent by virtue of section 26 of the Land Use Act will make that transaction null and void. We said that. And then we said that in line with that decision, the first case that came for interpretation on that particular section is Savannah Bank against Agilo. And I said to you that Savannah Bank against Agilo called her to give literal interpretation to that particular section by saying that yes, section 22 said that consent of governor must be obtained, and failure to obtain governor consent will render it null and void. And we also said that by virtue of section 26, and then Supreme Court affirmed Agilo's decision by upholding, by setting aside the mortgage transaction, as the case may be, and set aside the mortgage and allow him to go score-free, as the case may be. Now, we also said that Savannah Bank Agilo also has some other principles. Also has some other principles. Aside from the fact that the consent of government was interpreted in that case, you also have the fact that consent of government is applicable to both actual grant and also the deemed grant. Okay, actual grant and deemed grant. Actual grant, deemed grant. Okay, and then we also talk about the fact that subsequently, decision of the Savannah Bank against Aruna, National Bank against Adedeji, and then we also have cases like Ugochukwu and Cooperative and Commerce Bank Limited. And then I also mentioned Union Bank Nigeria PLC and Nayodare to you. And I said that case also issue of consent, but it's quite different. I also commit that to you to read. There's a particular journal of PPA that I would have loved you to read. If you have access to it, you see where Professor Smith examined the implication of Union Bank against Ayodare. Okay. That case, I think it was because the proper person that ought to have given consent wasn't the one that gave consent. And as such, the transaction was also declared null and void. Okay. Now we also talk about Awojugbagbe against Awojugbagbe light machine against Chinukwe, where the Supreme Court now said that yes, where you fail to obtain governor consent is not going to render it null and void, but rather to render it equate. That means incomplete, because equity C that has done which ought to be done. What you can do is now to compel any defaulting party that failed to obtain governor consent can easily go back to compel the defaulting party to obtain governor consent. I also gave you cases of McLean and Inlag, and then we move to section 28, no, section 24 of Land Use Act. And I said to you, section 24 of Land Use Act had to do with devolution of right of occupancy on death. Okay, devolution of right of occupancy on death. And I said that whether you inherit your property that's subject to customary tenancy or customary right of occupancy or right of occupancy, you can actually it divorce on you by mode of inheritance. Okay, by mode of inheritance. Okay, that is devolution of right under right of occupancy. Then we move to section 28, which is the revocation of right of occupancy. I said to you that section 28 to define overriding interest, and then under section 28 section 51 of Land Use Act, define what is overriding public purposes. We say it shall be lawful for governor to revoke right of occupancy for overriding public purposes. Okay, and I said to you, section 51 listed what are these overriding public purposes. Okay, section 51 listed what are these overriding public purposes. Basically, it has to be for exclusively for schools, hospitals, as the case may be, and majorly it has to be for government uses, and then usage as the case may be. And then I said that section 51 is not exclusive, because the word used there was include, meaning that anything that's not included under section 51 is not closed. It's talking about the fact that you can still have some other government interest in some other property that are subject to public use. Okay, and I gave you the case of offshore and foreign finance. We try to look at the Judem Generis rule. We say that anything that's similar to whatever government is trying to do is part of it. Then we talk about what are the procedure for revocation. Okay, what are procedure for revocation? We talk about section 28.6 and 28.7. Sorry, I'm sorry. Well, I just muted myself because I had to attend to certain things. Now, I talk about section 26, 28.6 and 28.7. Okay, 28.6 and 28.7, and we talk about what are the procedure that must be followed before you can actually, government can exercise its right under section 51 of the Land Use Act. Okay, 5 o'clock meeting. Under the Land Use Act, and we started by talking about the fact that the first thing that has to do is that the revocation must be by a person who has the power to do so. It must be by a person who has the power to do so, or person delegated by governor to do so. I said to you that even in issuance of consent of governor, appropriate ministry must sign a consent. So local government chairman cannot just issue revocation of land in an area situated in some area and say they want to revoke. Governor is the only one permitted to revoke, or where the governor has delegated, where the governor has delegated, we have 5 o'clock meeting. Tell us to come at 5. Where I say where governor has delegated the power to somebody else. Okay. Then number 2, notice shall be issued stating the purpose or revocation as prescribed by the act. That's another thing we look at. You have to state the reason. Purpose or revocation must be stated. If not, it's going to be declared null and void. Offshore and foreign finance is relevant, and then it requires military governor of Midwestern state is also relevant. So you don't revoke somebody else's land without giving reason. For why you are revoking that land. Okay, it's very essential for you to do so. You must give reason under that. So then number 3, notice shall be served on the order. Okay, notice shall be served on the order. You have to ensure that it is served based according to section 44. And how do you serve that? Delivery of a notice to the person to whom it is served, or by leaving it as usual no place of his abode, or if it's a company, you leave it in a registered place. The order must be, there must also be an acknowledgement. That's number 4, or the fact that the notice of revocation come into the notice of the person to whom that order is directed to. Okay, offshore and foreign finance also relevant in that regard. Okay, that is where we stopped yesterday. I also talk about, so now what is the effect? Then I also mentioned about revocation, that section 10 and section 8 of Land Use Act. And I said that ordinarily, when the revocation is based on overriding public purposes provided for, under the Land Use Act, you are entitled to compensation. Okay, you are entitled to compensation. You are entitled to compensation where the revocation is done. Where the revocation is done for overriding public purposes, you are entitled to revocation. Okay, but where the revocation is done in under Section 8 and Section 10 of Land Use Act, you are not entitled to compensation. I said that. Okay, you are not entitled to compensation as the case may be. You are not entitled to compensation. So this is another thing you need to understand. You are not entitled to any compensation where revocation is based on breach of terms. I mentioned that. Breach of term. But I said to you that in accordance with Section 36 of 1999 Constitution, you can make appeal to governor who probably will refill your appeal, and that has to be when your right of occupancy has been revoked for overriding public purpose. I mean, for breach of terms rather, not for overriding public purpose, not for overriding public purpose as the case may be. Now, under Section 10, Section 8, you are not entitled to any compensation. Under Section 8, Section 10, now under Section 28, for overriding public purposes, you are entitled to compensation. Okay, I said that to you. That's Section 29 of Land Use Act. You are entitled to compensation. And the compensation payable under Section 29, it has to be for unexhausted improvement. Nobody pays for the value of the land. You need to get it right. Nobody pay for the value of the land. Under Section 44 also, Section 44(1) of 1999 Constitution as amended also provide for a certain fact that you have a right to compensation. Okay, so the Section 44(1) of 1999 Constitution and then Section 29 of the Land Use Act provide for a compensation where your land was revoked for overriding public purposes. Okay, not for where your land is revoked for breach of terms or tenure as contained under Section 9 of Land Use Act. Section 9, Section 8, Section 10 of the Land Use Act. Okay, then we also talk about compensation for unexhausted improvement. Unexhausted improvements is what you are going to be paid for. Is going to be paid for, not necessarily for the value of the land. It is only whatever you have in that property that you are going to be paid for. Okay. If you look at section 51. Section 51 defines what is what is unexhausted improvement. It defines unexhausted improvement to include anything of any quality permanently attached to the land. That shows about the fact that what you are being paid for are including buildings, plantation, etc., not the value of that particular piece of land. If you have cassava on the land, they will measure and calculate how many sticks of cassava you have on that particular piece of land. Okay, that is how it's being paid. Now, Section 33. Section 33 of the Land Use Act, it talk about the fact that you may not be paid for compensation. Rather, in lieu of compensation, the government can resettle you. They can just put a resettlement on you by taking you to another place, okay? By giving you another alternative accommodation, okay? That is what it said, okay? Any question on what I've said so far? Let me see whether you are following me. Any question? Any question on what I've said?
Good afternoon, sir.
Good afternoon, sir.
Yes, good afternoon.
Yes, sir. With regards to the compensation aspect, you said you'd only be paid for things on the land. So let's say in a situation where a person just buys the land and has not yet started building and the government wants to acquire the land, would that mean he won't get paid for anything because there's nothing on the land as at the time he bought it? Sir?
Repeat your question. Can you repeat your question? I can't hear you.
Okay, sir. Am I audible now, sir?
Yes, you are.
Okay. My question is with regards to the compensation aspect. So, in the instance where a person just buys a land and has yet to, construct a permanent building or make any construction of any kind on the land, and the government decides they want to make use of that land, does that mean he will not be entitled to compensation because he has not yet placed any permanent structure on the land?
If he has nothing on the land, he may not be paying any compensation. Okay, that is it. Because compensation is not payable for the land. It's being paid for unexhausted improvement. That's the law. And if you also look at section 44 of 1999 Constitution, they are not going to pay you because they are going to assess it. Of recent, let me give you a good example to you. Of recent, federal government is constructing a road from Lagos. Okay, it's constructing a road from Lagos to Calabar. Okay, from Lagos to Calabar. Now there are many houses there. What they did was individuals submit their building plan, they access it, the photograph of whatever development you have on the land, and that's what you are going to be paid for. So what the government pay for is unexhausted improvement, not your land. If you have ordinary bare land there, you are not likely going to take anything. Thank you very much. Any other question?
Thank you, sir.
Yes. Another
Yes, sir.
question?
Good afternoon.
Yes.
Yes,
Good
sir.
afternoon.
Yes, sir. Please, can you go over section 33 again? I did not get what you said about it.
It says section 33 of empower the governor to over you in lieu of compensation resettlement. Okay, resettlement. You can be resettled. That's what we are saying. You can be resettled. What is resettlement? Instead of government giving you money as a form of compensation, they can give you alternative accommodation. They did that to people in Morocco now. Instead of giving them anything, what they did to them was just to relocate them. So instead of government to give you anything in terms of monetary compensation, they may just decide to go and resettle you somewhere. That is what I'm saying. Did you understand now?
Okay, sir. Thank you, sir.
Okay.
Sir, I have a question.
Yes.
So you said the government has the option to resettle you.
Yes.
Is there any basis on which they will resettle you? Can you ask them for resettlement instead of compensation for unexhausted improvements? Or are there special circumstances? Or is mainly at the discretion of the governor?
Well, I think that has to do. You have answered the question yourself. It's at the discretion of governor. When governor believe that it's better for you to be relocated or resettled, they will do it. Usually, when you look at most things, I mean, where they try to resettle people, they want to resettle them probably because they are community, okay, and they don't want them to. They can give them another land. I just mentioned of Morocco for you in Lagos, and then also there's what we call Ajibode resettlement scheme in Ibadan. Where a whole community was affected by the extension of University of Ibadan land. Okay, so what they did was to resettle them. Government resettle all of them by giving them another land instead of compensation. Now, let me tell you another thing about resettlement. Resettlement might not really be to your own advantage. You know why? If government granted you or give you alternative accommodation that's higher than your compensation, what you're entitled to, it's like a loan to the government. You may still be paying rent to the government. So this is what you need to understand. So it's better for you to be compensated than for you to be resettled. Usually it's very good for you to be resettled. Okay, that is one thing you need to understand about it. So what they normally pay for in quantum of compensation, they will look at extraction of building materials. Okay, which is in respect of how much do you collect as rent, how many years. So these are things they look at it in respect of building installation, improvement therein. That's part of what they are coming to assess. Why? It has to do with unexhausted improvement. Okay, and then basically also has to do with crops. If you are a farmer and you build so much on that place, they are also coming to look at your farm and assess it based on how many do you have on that particular piece of land, your crops, your tree, especially when you have economy tree, you get more compensation more than what you think. Okay, that is all about that. Okay, any other question?
Yes, sir. Good afternoon, sir.
Yeah, good afternoon.
So I wanted to ask, for the concept of notice, is it like anybody on the land that the notice can be served to, or there's a person that like the notice letter is being addressed to that must like take notes
As long
of
as
the
your name will be there now, the name of the holder will be, the letter will be addressed to the holder. And if the order cannot be found, and for example, if it's a company, they must serve a clerk or somebody who work in that office with an acknowledgement copy. That's for company. If it's individual and they can't find you in the house, they can give it to your security man, as long as he acknowledge the fact that he's going to give it to you. So he just to give it to anyone that can probably pass it to you. So, but your name as the holder will be addressed, okay, on that thing. Aside from that, government normally do certain things. You don't stop at serving notices. Another thing they normally do is to take another step forward by advertising in the newspaper circulating within the area. Okay, but that one is also faulty because what happened in case you did not see the newspaper? This is another thing we need to address. Okay, I think I asked a question 1 year like that, where somebody advertised in the newspaper and without personal service of the notice of revocation. I think that is also not valid enough. Okay, that is it. But you know, when they want to revoke, your name will be there. It's your name that they will address it to your name, and then you are the one that will be served. But in case they can't serve you, they serve whoever will receive it on your behalf. Thank you. Yes, other people are raising up their hand. Who's the Bukunoluwa Ishola? Okay, who else? Who else is asking question?
Good afternoon,
Yes, sir.
sir.
Yeah, good afternoon.
Okay, can I go first? Thank you, please. My question is I'm sorry to bring equity into this, but isn't it inequitable for a person's right to statutory occupancy be revoked without compensation simply because the person is yet to make some unexhausted improvements on such land? Or do we have cases where this has happened and
what
the
I
person
just said to you now, whether it's inequitable? What I said to you that is not the value of the land they are paying for. If they are paying for the value of the land, you are likely going to get more money. But it's not for the land. It's not for the land. What you are being paid for is unexhausted improvement. If you are talking about not being equitable, I don't know what kind of compensation you want to receive when you have not developed your land. When the law is actually clear, you are not the only one whose land is being taken. If it's for variety public purposes, they want to construct road. Are you not going to benefit from the road? If it's for pipe borne water, are you not going to benefit from the road? So if you are looking for that equality, equity is equality. That's number one. You don't look at it that the government want to tar road. Are you not going to drive your car on that road? So I don't believe so. They can't pay for the value of land because the compensation will be higher. Let me not deceive you. For example, where a land is now 100 million naira, and then the compensation payable also varies. It's not that everybody is going to be paid the same amount of money. It depends on the valuation report of your unexhausted improvement. So if I put duplex and I have beautiful houses with all the building material, very expensive, you don't expect me to get the same compensation with somebody that put a box cutter on his land. But if land is being paid for, the implication is that all of us are going to get equal compensation. So I think the philosophy behind it has to do with the fact that no, we don't pay for land. We pay for unexhausted improvement. I don't see anything wrong. You are talking about that one. What happened to where or situation whereby the land was revoked for breach of terms? Nobody is going to pay you for anything. And there's nothing you can do. That is kind of power we're talking about. Under the land users, that the power given to the governor of a state is too much. Is Alpha and Omega when it come to that was governor of a state actually replaced what the Nekitobi said in Abraham against Olorun Fumi. Is the Alpha and Omega. Governor can do anything about any land in the state. Nothing will happen. I know a land that I'm representing a client along the Express Ibadan Road. Governor of Ogun State just revoke. Just come around and just revoke and assign the land to Chinese company. That is how powerful they are. Foreign investor is coming to Nigeria. They need land. They want land. So when they want to take land, they want to do all that. What is likely going to happen is that the governor will just enter any land and just revoke. So if it's for variety public purpose, there's nothing. It's an unexhausted improvement, and then you are being paid based on what you have actually do. If you are an holder of a right of occupancy, whether you are an holder or no holder, basically what you're entitled to is unexhausted improvement because nobody pay for the value of the land. Okay, And that is just like I said, this is not first thing in Nigeria. Most of the law you see in Nigeria were carbon copy of law in India and the United Kingdom of United Kingdom. It's not like a law that stand alone. Let me not deceive you. Majority of the law you have in Nigeria, some are copied from India, some are copied from UK. So, and these are developed countries. Thank you. Whether it's inequitable or non-equitable, I believe the justice will be that if you get a land, develop it. Thank you. Any other question?
Yes, sir. I have a question.
Yes.
Okay. In the last class, you spoke about revocation, where it is shown that the revocation was not done by overriding public purpose.
Yes.
I think you were saying that the owner, the landlord, can actually revert. The land can be given back to the owner. I don't know, is that
I say you appeal to the governor. You can appeal to governor. That's what I said. If it's based, you can appeal to governor. Governor might listen to you. Governor might not listen to you. If governor listen to you and he believe your case is meritorious, I say if your land is so big, if they've not put eyes on it, they can return part of it to you, or you lose everything. That's what I said. Do you understand now?
Yes, sir.
Okay, so what's your question now? What's now your question? Hello? Is that your question? Was that your question? Okay, next question, please. Is there any other question, or we should proceed?
Hello, sir. Can you hear me, sir?
Yes, I can hear you.
Can you hear me, sir?
I can hear you. Go on.
Question.
Yes, go on.
Okay, on 44C, that the service of a notice. Okay, I'm saying that can we infer from section 44C that the service of a notice must be by a letter, or is there any other means by which a person can be served notice?
Yes, it has to be by letter. There's a notice. Okay. After that, they will gazette it. It's a government notice. Government will write you first. That's the way they do it, and then to be gazetted. That's the way government communicates. Government communicate their final decision by gazettes. Okay. So, but what they will do to you is to send a letter to you. So it's going to be by letter. Thank you.
Thank you, sir.
Any other question?
Good afternoon, sir.
Good afternoon.
I wanted to ask, under this payment of compensation thing, are they paying both the holder and the occupier, or just the person that erected the unexhausted improvement?
What did you say?
I said for payment of compensation, are they paying both the holder and the occupier, or just the person
one of the problem I told you when I started this class with you. I said that's one of the problems generated by the Land Use Act for using the word holder or occupier interchangeably. I said that to you. And I said to you, one of the problems has to do with the fact that if the land is being used for agricultural purposes, so who is going to be compensated when the farmer who is farming on that particular piece of land is not the holder but occupier? I said that to you. But actually, where a land is being used for agricultural purposes, who puts anything on that land? The crops are owned by the occupier. Occupier may not necessarily be the holder. Okay? So, and I gave you the case of Abiria and Yakubu, which is part of what we are going to be looking at from next week. We are going to look at the implication of Land Use Act on the customer land tenure system. Okay? Because the fact in Abiria and Yakubu is the fact that when the acts talk about either the holder or occupier, the problem has to do with father who is the occupier, who is the holder. So occupier is the one that occupied the place. Okay, but I think if it's for purpose of compensation, just like what I said, and the compensation is being paid for unexhausted improvement, whoever has improvement on that land will be compensated, and this is going to be the occupier, especially when the land is being used for agricultural purposes. When it's a land being used in an urban area, occupier cannot expect to be paid compensation. A good example, a man built 10-story building and he let it out and he has tenants. Tenants are the occupier. That is what they call de facto possession. Okay, where the de jure possession is in the hand of the owner. So it's not there. So all the improvement they are paying for is not your bed, it's not your kitchen utensils. They are paying for the building, and they are going to pay for the building extraction. So as a tenant in the city, you are the occupier, but you are not the one entitled to compensation. I think the occupier being paid compensation and the problem had to do with when such land fall within the category of land being used for agricultural purposes. Okay, so that occupier, and I give an example of customary tenant. There's what we call customary tenancy, which you are going to do. I think after this class, you are going to look at customary land tenure. We were able to look and identify the fact that this is where somebody who owned land now decided to give his land to somebody to farm, and then in acknowledgement of the overlord or the title of the owner, he gives what they call customary tribute. You find all these people from Benue. If I'm from Benue, I'm sorry, I'm not offended, but Benue people can farm. They are very good in farming. Okay, when you look at Benue people, what do they normally do? Benue people farm a lot, and then but they come down to Southwest to farm. And when they come to Southwest to farm, majority of their land are being given to them by the villagers. So some of them have stayed for years. I've seen where some of them have intermarried, and then suddenly they plant yam, they plant cassava, they plant etc. And then government now decided to use the land for variety public purpose. The question is, who is entitled to compensation? That has to be that stranger, the customary tenant, because the owner of the improvement of that land, because compensation has not been paid for land. I don't know whether I have answered your question. Have I answered your question?
Yes, sir. Thank you.
Any other question? Any other question? Now, basically, the land users, just like I said, is an act that, if you look at the preamble, I believe Promos have talked about preamble. The preamble of the land user is to make land accessible to citizens. That's the purpose of the land user, to make land accessible to citizens. Okay, that is one of the primary motives. And it's because of the fact that they want that land to be accessible for agricultural purposes. That was when a former president in Nigeria introduced Operation Feed the Nation. They want land to be accessible. Okay? So if land is now accessible, by now putting the land under the control of governor. But the problem has to do with the fact that the purpose has been defeated. And this is another area I want you to look at. Are you saying that the Land Use Act has justified the preamble and the purpose for which it was actually enacted? No. To make land accessible is so expensive for a poor man to apply for right of occupancy. The reason why people don't apply for CFO is very expensive. In some states now, they try to now just look at way around by saying that you can apply for small certificate of occupancy if you have built your house on the land. They will tell you is ownership certificate of occupancy. They are doing it in Oyo State, they are doing it in Ogun State, which is quite different from the normal certificate of occupancy. It's so expensive. The land is supposed to be made accessible to citizens, that's number one. And that is the primary objective of the Land Use Act, where citizens can access land for the purpose of agricultural purposes. But if you look at it, it's now being defeated. Governor is exercising his power under Section 1, which is more or less arbitrary, because the power of governor under Section 1 is where you see that he's in charge of all the land vested in the territory of his state. The vesting power under Section 1 is so powerful that governor become the radical title to land in a state. So I want you to go and read the preamble to Land Use Act, okay, and look at whether that act is not due for amendment or even total repeal. And then to make it difficult for you to be able to amend Land Use Act, it was incorporated as part of the Constitution. Okay, I think Section 315 of 3156 or so of whether 3156 of 1999 Constitution. They made it difficult for you to amend. It has become part of the Constitution. So if you have something as part of your Constitution, you can see the amendment procedure. Everybody has been clamoring for the amendment on Land Use Act. Nevertheless, people cannot amend it because of that problem in place on that constitution. So it was part of schedule which was incorporated. There are 3 laws that were there. I think the NYSC law, the legal aid law, and the land use act. They were under that law that was, make it practically impossible for you to be able to amend. And the implication is the fact that you have to also look at the procedure for amendment of the constitution. But governors are really enjoying. I've never seen any governor who has served in any state that doesn't have land to the extent that is giving land to his cronies and friends because you have access to land. Governor have access to land. It's your least problem. Honestly speaking, if you become a governor, it's your least problem. You just wake up one day and just look for any area where land are still virgin and you see those areas and you just say the government want to use the land. Nobody can query you. These are problems we face with land users. So I want you to go and look at the preamble of land users and look at the effect of it vis-a-vis about the fact that what are the preamble to the land users as they really justify the purpose for which it was enacted. The purpose for which it was enacted is a problem, and we need to look at it. Okay, we need to look at it. So these are things you need to actually look at. So go and look at the preamble to the land use act. Look at it critically as part of, if you have not been taught, look at it critically. Why is it land user? Because the question might be that why can't we amend the land use act? Why can't we amend the land use act? Why is land use act still there? I know all of you don't like land use act. You don't like land use act because of the problem created under the land use act. Okay, so we may need to look at that and also examine the fact that land use act ought to have been amended, especially when you have this kind of power being given to the governor of a particular state who can revoke and then at will and just decide to give people patriotism. Of recent, if you look at what is happening, if you are driving on Tom Milan Bridge towards Unilag, those are Santis, but you can see the fact that they are just trying to clear those areas and they are sending people away. Okay, now that is power of governor. Governor can inspect, can enter any land for the purpose of inspection, and there's nothing you can do about it. Okay, I want you to go and look at the preamble and look at the justification or the fact that is it an act that should be retained in view of what you have learned so far about the power of governor to just revoke and pay people patriotism and people just disappear. People cry and there's nothing you can do about it. Okay, that's all about that. Now, the next thing we need to look at, we'll talk about compensation. We'll talk about under section 29, and I said to you that under section 29, what you are eligible to is just unexhausted improvement, building material. They are going to assess your building. Not the land. They will look at what you put on structure. Reason why somebody who build a gigantic building will get more money than you, even though you are a neighbor. So it is part of it, which I believe is also equitable. If they can pay for land, if they are paying for land, meaning that everyone in that location will be paid equally. Now that's number one. Then number two is about the fact that for land being used for agricultural purposes, you are also entitled to compensation based on the number of the crops you have on that particular land. People that have cassava on their land or yam tuber will not likely get compensation more than people that have economy trees on the land. If a land is being destroyed, there are cocoa, there are palm trees, they are going to get more compensation than what we said. Now, somebody asked me about the issue about compensation to communal land, which is another problem. Who take compensation? It has to be the head of the family, but the head of the family hold it as a trustee for the members of the family. It has always been a problem. But the issue of older occupier is a problem. I said that to you because that's what happened in Abiria and Yakubu. I asked people to go and read that case. Abiria and Yakubu is one of the cases that people decided to take advantage of the fact that, yeah, we are the occupier. We are the farmer here. We should be the one entitled to compensation because we have land. We have crops on that particular piece of land. You can also read the case of Onwuka against Ediala, as the case may be. Now, aside from that, section 48, I've not jumped to section 48 of land user. Section 48 of land user has not abolished any pre-existing land payment system. Okay, don't believe that Land Use Act has abolished all pre-existing land tenure system. No, we still have customary land tenure system till today. We still have it, okay? And we still have land that's subject to English doctrine of estate today, okay? But the question has to do with the fact that you are still operating as if you are a deemed grantee of whatever right granted to you. The next one, so Section 48 preserve all existing land tenure system, either under customary law or non-customary land tenure system. Now, we are dealing with customary land tenure system now. Customary land tenure system have to do with where up to today, Omonilers are still selling lands, okay? Omonilers are still selling land. It's not as if Omonile are not selling land. They are still selling lands. Okay, and the document they will give to you is an equitable interest, but you can perfect it by applying under Section 5, which is actual grant. Yes, I saw one and on Olawumi Bakari. You want to ask a question? Olawumi Bakari, do you have a question? Olawumi Bakari, are you raising up your hand?
I have a question, sir. Is as regards the definition of unexhausted improvement.
Yes.
So it says, sorry, sir. It says, but does not include the result of ordinary cultivations other than growing produce. But
ordinary cultivation other than growing produce. Yes, now it's clear now. Yes, what is the issue there?
Then it continues to say interest at the bank rate. Means a simple interest. Okay, I think it's supposed to be separate. They joined it together. Thank you, sir.
It's not there. It's saying that other than growing produce. So if you cultivate your land, you have not planted. You cultivated your land without planting anything. You are not going to be entitled to anything. Before your land is acquired, you are maybe or revoked. You are still cultivating. They are trying to put ridges, and you have not planted anything. Okay, there's nothing for you to do. That's what we are saying. Just like the question somebody asked, whether if somebody with an ordinary land is to be compensated, and we say no, you cannot be compensated. Okay, any other question, please? So we move to section 48 of the Land Use Act, which has said preserve every existing land tenure system. Now, section 39 is talking about conferment of jurisdiction on the High Court. Now, what happened in those days? There was a particular case which now limited the right of a state High Court to hear cases over land that are not in urban area, which have now been settled. So Supreme Court overruled by saying that because if you are challenging land that are subject to customary land tenure system, you need to go to area court and customary court. But Supreme Court has actually overruled that in a decision against Onyiwola by saying that by virtue of section 2721 of 1999 Constitution, the state government, the state High Court is given unlimited jurisdiction, so to say. So we need to understand that situation, okay? It's being given unlimited jurisdiction, okay? So we have that, you need to understand Adisa Onyilola in that regard. Now, for now, I think these are the salient you're supposed to know under the basic section of the Land Use Act. Okay, the second thing we need to look at, which I'm going to conclude to you next week, has to do with effect of Land Use Act on the customary land transaction. I'm not going to teach customary land transaction because somebody else is teaching it. I will only mention to you what has Land Use Act, how has Land Use Act impacted on that. Okay, we don't want to come back to class. We want others to take their chance, their time. Only what we normally do is to come back after the customary land tenure system must have been taught. But we'll look at it because if you don't understand customary tenancy, you don't understand customary pledge, customary COLA system, I don't know where we have to teach customary, effect of it on the land user. But for now, let's just assume that this is what we are supposed to know under the Land Use Act. We have been able to tell you from section 1 of this act. And today, I also make you to go back and read preamble to the Land Use Act. I'm telling you now, what are the objectives of land users? And I said that one of the objectives of land users is to make land accessible to citizens. Okay, I said that to you. And then from section 1 to section 2, section 5, 6, we look at section 34, 36. We come back to section 21, 22. We look at section 6. We look at section 8, 10, which is talking about revocation for breach of terms. These are things we look at, and I want you to really consider that, okay, as part of what we have looked at. Okay, any question? If no more question, we end this class today.
I have a question.
Yeah, what's the question?
Can you contest the amount of compensation I was paid to you?
Can I do what?
Can somebody contest the amount of compensation that was paid to them?
What do you want to contest?
That the money is too small.
You will not be there when they, let me give an example. My client was giving small money on Coastal Road, and he raised the same question with you, that the money they gave to him was not equal. Before he even raised, when he went back to the house is on ground already, because it was a coastal road and it was on ground already. Who are you going to talk? Yes, if you believe that the community, you can appeal to governor. They will look at it. But really, what they normally do, they look at the same houses and based on their completion on sale. Okay, just like I said, they are not paying for. You are going to do valuation yourself, so you are not just going to submit what they call your building plan. You're also going to submit your what they call your valuation report. What they will ask you to value your property yourself. And when they are reducing it, actually, let me be sincere with you, they don't usually pay you what you will contest. That's the truth. They pay you reasonably based on what you have submitted. It might not be equal, but it's not going to be different as such. Okay. Any other question?
Yes,
Any
sir.
other question?
Yeah, good
Yes.
afternoon, sir.
Good afternoon.
Sir, good afternoon, sir. I missed what you said on section 24 when you were talking about devolution upon death
Devolution of right.
and
That's
your
it.
explanation on excision.
Excision. Excision has passed. I was just talking about excision since when? I was talking about when your land was acquired for varying public purposes. And I said the practice now, I mean, when they acquire land, if government need, I mean, what they need is just 20 acres. They will go and acquire 100 acres. And then later, communities will come and appeal to governor to release part of the land to them. And they will seize it. That's what they call excision. They will release the already acquired land to that community. Do you understand now? That's what they call excision. The second one has to do with devolution of right. Yes, I say you can inherit right of occupancy granted by governor. If your father is the holder of a right of occupancy and he has passed on, you can inherit the property. That's what I'm saying. That's what section 24 is talking about. Do you understand now? Do you understand?
Yes, sir. Thank you, sir.
Thank you.
Yes, sir. Thank you, sir.
Any other question, please? No more question? Everything is perfectly understood.
Hello, sir.
Very brilliant.
Hello, sir.
Yes.
Yes, sir. My own question is bordered on the clearing of road that you mentioned across Third Mainland. Because yesterday I passed that area, so I saw that a certain community had been cleared, and someone told me that it's because of fire raised the area that government claimed the land. But I could not really. I think it's the Makoko. I think Makoko community. Fire raised like the area, and they said the government used that excuse to like reclaim the land from them. But I could not engage the person.
Yes, if there's no safety, you know, I said to you that government have power to also inspect, enter any land for the purpose of inspection and the purpose of seeing, prevent dangers and everything. Lagos is common, and when there's any light, they want to come, or when a building collapse, they are empowered under the section, I think section 14, section 15, 14, 8, they can enter now. 7, from section 7, yes. Do you understand?
Yes, sir.
But
yes, sir.
Governor, if they are ready to rebuild their land, they will test the integrity of the building. Governor will not allow you to move in and just be building into a property that is not they've not tested. They first of all test the integrity whether the building should be demolished entirely, or you can still continue to be built. Do you understand me?
Yes, sir.
Okay. Any other question,
Good.
please?
Thank you, sir.
Any other question?
Yes, sir. Good afternoon, sir.
Yeah, good afternoon.
Yes, sir. Please, I want to confirm if the building in question that is to be claimed by the government is like a building that has been put on rent, would the government also consider the fact that it is sort of a business enterprise when calculating the compensation, or they will just pay me for the house alone?
What concern them with the tenant? They will look at the value of the rent too that you are collecting. That's basis where they are paying you compensation. They will think about it. In payment of compensation, they will look at the rent you are collecting. Do you understand?
Yes, sir. Yes, sir. Thank you,
so
sir.
that when you are sending them away, you tell them they were about to demolish, you take your rent back. But some wicked landlord will not do so. They will need to know what is the rent you collect per annum, and they probably factor that out in paying you compensation. It's still under the land users. Okay.
All right, sir. Thank you, sir.
Okay. See you next week. See you tomorrow in equity. Have a wonderful evening. Bye bye. Yeah.
Thank you, sir.
Sure.
Bye-bye, sir.
Yeah, bye bye.
Thank you, sir. Thank you, sir. Thank you, sir.
Thank you, sir.
Bye bye.